I built that shed with my own hands on land I legally own, land registered under my name, recorded in county documents, surveyed and certified to the inch, sitting a full 20 feet inside my property line, well outside any easement or HOA jurisdiction. So when I came home one morning and found it gone, erased, reduced to splinters and hauled off like it never existed, and saw Elise Warner, the HOA treasurer, standing in my driveway with a clipboard and that smug little smile people get when they think a printed form makes them untouchable, telling me my shed violated community standards. Something inside me went cold. Community standards don't apply on land the HOA doesn't control. And she knew it. That shed wasn't just a place to store tools. It was the first thing I ever built after buying this land outright. A piece of peace I carved out with my own labor, my own money, my own sweat. She thought I'd fold. She thought I didn't know the law. She thought wrong. If you've ever dealt with HOA overreach, drop a comment. You're not alone. And trust me, her downfall is already in motion. The shed went up in 2 days back in June, right after I closed on the property. I remember the heat that weekend, the way sweat soaked through my shirt by 10 a.m., the satisfying bite of the circular saw through pine beams. It wasn't complicated work, just honest labor, the kind that leaves you tired in a good way. 4 walls, a pitched roof, a door that hung straight and closed tight. I built it well inside my property line, measured carefully because I knew exactly where my land ended. The county surveyor had marked it all out 3 years earlier when I bought the place. Steel pins driven into the ground at each corner. Every boundary was documented, certified, and legally bulletproof. The neighborhood was quiet back then, the kind of place where people waved from their driveways and kept to themselves. The HOA existed, sure, but it felt more like a formality than anything with teeth. They maintained the entrance landscaping, organized the annual barbecue, and sent out reminders about trash pickup schedules. I paid my dues on time, kept my grass cut, and never caused trouble. The shed was for tools, mostly. Lawn equipment, some camping gear, boxes of things I didn't need in the house but wasn't ready to throw away. It sat back from the road, partially screened by the line of crepe myrtles I'd planted the first spring. Modest, functional, entirely mine. I didn't ask anyone's permission because I didn't need to. It wasn't in a common area, wasn't blocking a sight line. The HOA covenants I'd read cover to cover said nothing about structures on private lots set back from the street. For 6 months, nobody said a word. I'd see Elise Warner sometimes at the mailbox cluster, always dressed like she was headed somewhere important, even if she was just checking for catalogs. She'd nod, smile in that tight way people do when they're being polite but not friendly, and keep walking. She was the HOA treasurer, a position she'd held for years, the kind of person who showed up to every board meeting with color-coded binders and printed agendas. I didn't think much of her. She seemed efficient, maybe a little overly invested in the minutiae of neighborhood governance, but harmless. I had no reason to think otherwise. The first sign that something was off came on a Tuesday in December. I found a letter in my mailbox. Not the usual HOA newsletter, but a single sheet of paper, printed on generic office stock, no official letterhead. It was short, almost casual in tone. It noted that a structure had been observed on my property and requested that I contact the board to discuss compliance with community guidelines. No specific violation cited, no reference to a particular bylaw or covenant, just a vague request for a conversation. I read it twice, looking for clarity that wasn't there, then set it aside. I figured it was a clerical error, maybe someone new on the board who didn't understand property lines. I made a mental note to call the management company after the holidays, and forgot about it. 2 weeks later, another letter. This one had a slightly sharper edge. It referenced the previous communication, expressed concern that I hadn't responded, and suggested that failure to address the matter could result in further action. Still no specifics, no section number from the covenants, No clear explanation of what rule I was supposedly breaking. I called the management company that afternoon and got a receptionist who put me on hold 3 times before telling me someone would get back to me. No one did. I sent an email to the general HOA address, polite but direct, asking for clarification. I attached a copy of my plat map, highlighted the shed's location well inside my boundary, and requested a written explanation. The reply came 4 days later. A single sentence. "Your concern has been forwarded to the board." That was it. I started paying closer attention after that. I noticed Elise's car idling near my driveway one Saturday morning, her head turned toward the shed, phone in her hand like she was taking pictures. When I stepped outside, she drove off without acknowledging me. A few days later, I saw her talking to my neighbor across the street, gesturing in the direction of my property. My neighbor shrugged, said something I couldn't hear, and went back inside. The unease I'd been pushing down started to solidify into something sharper. This wasn't a clerical error. This was deliberate. I pulled my property deed that night, laid it out on the kitchen table next to the survey documents, and went through every page with a highlighter. Nothing in those documents gave the HOA authority over what I did inside my own property lines. But Elise Warner kept watching, and I started to understand that being right wasn't going to be enough. The third letter arrived in January, and this time it came with a case number printed at the top. Case number, like I was being investigated for something. The tone had shifted from polite inquiry to bureaucratic formality. It referenced Section 7.3 of the HOA covenants, claimed my structure violated aesthetic standards, and gave me 14 days to respond or face penalties. I pulled out my copy of the covenants that night and flipped to Section 7.3. It covered exterior paint colors for homes. Nothing about sheds. Nothing about outbuildings. Nothing about structures on private property at all. I read the surrounding sections twice, looking for anything that might have been misinterpreted or stretched to apply. There was nothing. I called the management company again the next morning. This time I got through to someone who identified herself as the community liaison. I explained the situation, cited the section number, and pointed out the obvious disconnect. She put me on hold for 6 minutes, came back, and told me the board had discretion to interpret covenant language in the interest of community harmony. I asked what that meant in practical terms. She said I should submit a written response to the board and attend the next meeting if I wanted clarification. The next meeting was 3 weeks away. I said I'd be there. She said she'd note it in the file. Then she hung up. I started digging deeper that weekend. I went back through every HOA communication I'd ever received, looking for anything that might explain where this was coming from. Most of it was routine. Monthly newsletters, reminders about pool hours and parking regulations, annual budget summaries. Then I found something tucked into a notice from 6 months earlier. A single paragraph buried at the bottom of a page about upcoming road repairs. It mentioned a board initiative to expand recreational common areas, and said the HOA was evaluating underutilized spaces within the community. Underutilized spaces. The language was vague enough to mean anything, or nothing. But it stuck with me. I looked up the HOA budget online, the summary version that they post every year for homeowners. The numbers were general, broken into broad categories: landscaping, maintenance, insurance, administrative costs. Nothing unusual. But there was a line item for capital improvements that had doubled in the last 2 years. No detail, no explanation, just a number that kept growing. I made a note to ask about it at the meeting. The email came 3 days before the board meeting. It was from Elise directly, not the management company, sent from her personal address. The subject line read, "Final Notice." She wrote that I'd failed to comply with multiple requests to address the violation, that the board had reviewed my case, and that I was now subject to a fine of $50 per day until the structure was removed or brought into compliance. Brought into compliance with what? She didn't say. The email cited Section 12.4 as the authority for the fine. I looked it up. Section 12.4 dealt with fines for late payment of HOA dues. It had nothing to do with structures or violations or anything remotely connected to my shed. I printed the email, highlighted the section reference, and added it to the folder I was building. Then I wrote back. I kept it short. I pointed out the error, asked for the correct citation, and requested documentation of the board vote authorizing the fine. I hit send and waited. Her reply came 6 hours later. One sentence. The board acts in accordance with recorded procedures. No apology, no correction, no documentation. That night, I sat at my kitchen table with everything spread out in front of me. 3 letters, 2 emails, a copy of the covenants with half a dozen sections highlighted and cross-referenced. This wasn't confusion. This was a tactic designed to make me think I was the one who didn't understand how things worked. Elise Warner was counting on me not checking, counting on the weight of official-sounding language to make me fold. The board meeting was in 2 days. I wasn't folding. I was showing up with every piece of paper she'd sent me, every citation that didn't match, every claim that fell apart under scrutiny. If she wanted to play the authority card, she was going to have to prove she actually had it. And something told me she couldn't. The board meeting was held in the community center on a Thursday night, a small room with folding chairs arranged in rows, facing a table where the board members sat. I got there 15 minutes early. Elise Warner sat at the center of the table, flanked by 3 other board members, her binders open in front of her, pages marked with colored tabs. She glanced up when I walked in, held my gaze for a second, then looked back down. No acknowledgement, no greeting. I took a seat in the 3rd row and set my folder on my lap. The meeting started with routine business, approval of minutes, a discussion about repaving the walking trail, a complaint about holiday decorations. Elise ran through each item with practiced efficiency, calling for votes, moving on before anyone could ask follow-up questions. 20 minutes in, she turned to new business and looked directly at me. Mr. Cole has a structure on his property that violates community standards. We've sent multiple notices requesting removal. To date, he has not complied. I raised my hand. She ignored it. One of the other board members, an older man with reading glasses, leaned forward and said, "I thought we were going to hear from him first." Elise's jaw tightened. She said homeowners could speak during public comment at the end. I stood up anyway. I said I'd appreciate the chance to address this now, since it directly concerns me and there seems to be confusion about the facts. The room went quiet. Elise stared at me, then glanced at the other board members. The man with the glasses nodded. She exhaled slowly and gestured toward the front. "Fine. Keep it brief." I walked to the front and turned to face the board. I opened my folder and pulled out the first letter. I said I'd received 3 letters and 2 emails, all claiming my shed violates HOA rules, but none of them cite a rule that actually applies. The first letter referenced Section 7.3, which covers paint colors, not structures. The email cited Section 12.4, which deals with late dues, not compliance. I held up each document as I spoke, then set them on the table in front of Elise. My shed is on my private property, 20 feet inside the boundary line. It doesn't fall under HOA jurisdiction. Elise didn't look at the papers. She said the board has the authority to interpret covenants in ways that serve the community's best interests. I said interpretation requires a basis in the actual text. What section are you interpreting? She hesitated, just for a moment, then said, "We've received complaints from neighbors about visual impact." I asked who complained. She said that the information is confidential. I asked when the board voted to authorize fines. She said the board doesn't need to vote on enforcement actions. That falls under the treasurer's discretionary authority. I asked where that authority is documented. She didn't answer. The man with the glasses cleared his throat. He said, "Elise, maybe we should table this until we review the specific covenant language." One of the other board members, a woman in her 50s, spoke up. She said we need to respect the treasurer's authority on enforcement matters. We elected her to handle these issues. Tom looked at her and said, We also have a responsibility to homeowners to follow our own rules." Elise's face flushed. She said, "We've already spent enough time on this. The violation is clear, and Mr. Cole needs to remove the structure or face escalating fines." I said, "I'm not removing anything until someone shows me a legal basis." She leaned forward, her voice dropping into something harder. "Then you'll be fined $50 a day starting tomorrow. And if you don't pay, we'll file a lien against your property." A lien. The threat hung in the air like smoke. A lien meant they could claim a legal interest in my property, cloud the title, and make it impossible to sell or refinance. It was a nuclear option, deployed in front of a room full of witnesses. I looked at her, then at the other board members. None of them met my eyes. I said, "Filing a lien requires a legitimate debt. You don't have one." She said, "The board determines what's legitimate." I said, "No, the law does. And I'll be happy to explain that to a judge if it comes to it." I picked up my folder and walked back to my seat. The room stayed quiet. Elise shuffled her papers, said something under her breath to the board member next to her, then moved on to the next agenda item like nothing had happened. But her hands were shaking. I could see it from where I sat. She'd overplayed. She'd threatened a lien in public, on record, without legal standing. And now it wasn't just between us anymore. I stayed until the meeting ended, watching Elise avoid looking in my direction when people started filing out. A few glanced at me, some with curiosity, some with sympathy. One woman stopped and said quietly, "Good for you." Then she left. I sat there for another minute, alone in the empty room. The binders were gone, the laptop closed, but the threat was still there. I walked out into the parking lot and got in my truck. My hands were steady. My breathing was calm. But inside, something had shifted. This wasn't about a shed anymore. It was about power, about someone who thought a title and a clipboard made them untouchable. Elise Warner had just made it personal, and she had no idea what she'd started. I came home 3 days later to find the shed gone. Not damaged, not broken into, gone. The concrete pad was still there, swept clean except for a few splinters of wood scattered near the edges. The crepe myrtles behind it were trampled. Branches snapped, leaves crushed into the dirt. Tire tracks cut deep into the grass where something heavy had been driven across my lawn. The tracks looked commercial, probably a flatbed or a demolition truck. Someone had hired contractors to do this. I stood in the driveway for a full minute, staring at the space where the shed had been, trying to process what I was looking at. Then I pulled out my phone and started taking pictures. I walked the perimeter of the property, documenting everything. The tire tracks, the broken branches, the scraped concrete where they'd dragged or lifted the structure. I took wide shots and close-ups, made sure the timestamps were visible, and checked that the county survey pins were in frame to prove the location. Then I called the police. The dispatcher asked if there was an emergency. I said no, but I needed to report a destruction of property. She said she'd send an officer out. It took 40 minutes. The officer who showed up was young, maybe late 20s, with a notebook and a body camera clipped to his chest. He listened while I explained what had happened, looked at the empty pad, and walked around the yard taking his own notes. He asked if I knew who did it. I said yes, the HOA. He stopped writing and looked up. The Homeowners Association, I said yes, specifically the treasurer, Elise Warner. She threatened this at a board meeting 3 days ago. I have witnesses. He asked if I had any proof that the HOA was responsible. I said the timing isn't a coincidence, and no one else has a motive. He wrote something down, then said he'd file a report, but this might be a civil matter, not criminal. I asked what the difference was. He said if the HOA believed they had authority to remove the structure, even if they were wrong, it might not meet the threshold for criminal destruction of property. I'd need to talk to a lawyer. I thanked him and watched him drive away. Then I stood there in my yard, looking at the empty concrete pad, feeling something cold and sharp settle in my chest. They'd done this while I was at work. They'd come onto my property without permission, without a court order, without any legal authority, and erase something I'd built with my own hands. The shed itself wasn't valuable. Maybe a few $100s in materials, a weekend of labor. But that wasn't the point. The point was, they'd decided my property rights didn't matter. They'd decided a clipboard and a title gave them the power to take what was mine. I went inside and pulled up the HOA website on my laptop. There was a contact form, a phone number for the management company, a page with board member names and emails. I sent an email to the general address and copied every board member. I kept it factual. I stated that my shed had been removed without my permission, without a court order, and without legal authority. I noted that the structure was on my private property and that I had documentation proving ownership. I requested immediate reimbursement for the cost of materials and labor, a written apology, and an explanation of who authorized the removal. I attached photos of the empty pad, the tire tracks, and the broken branches. Then I hit send. The reply came 6 hours later. It was from Elise. 2 sentences. The structure was removed by authorized contractors in accordance with HOA enforcement procedures after multiple violations and failure to comply. No further action is required on your part. That was it. No apology, no explanation, no acknowledgement that they'd destroyed my property. Just a bland assertion of authority that didn't exist. I printed the email and added it to my folder. Then I opened a new browser tab and started searching for property attorneys in the area. I found 3 who specialized in HOA disputes, sent inquiry emails to all of them, and got a response from one by the next morning. Her name was Rebecca Marsh. She said she'd handled cases like this before, that HOA overreach was more common than people realized, and that I likely had grounds for a lawsuit. She offered a free consultation. I took it. We met 2 days later in her office downtown. I brought everything: the letters, the emails, the photos, the police report, the property deed and survey documents. She went through it all methodically, asking questions, making notes, nodding occasionally. When she finished, she leaned back in her chair and said, "You have a strong case. The HOA had no authority to remove a structure on your private property. They didn't follow due process. They didn't get a court order. This is a clear violation of your property rights." I asked what the next steps were. She said we filed a lawsuit for destruction of property, trespass, and potentially conversion. We demand reimbursement for the shed, compensation for your time and distress, and attorney fees. We also send a demand letter first, giving them a chance to settle before we go to court. Most HOAs don't want the publicity or the legal costs. They'll fold. I asked how long it would take. She said it depends on whether they settle. It could be a few weeks. It could be months. I asked what it would cost. She said she worked on contingency for cases like this, meaning she only got paid if we won or settled. I didn't have to pay up front. I said, "Let's do it." She smiled and said, "I'll have the demand letter ready by tomorrow. In the meantime, don't communicate directly with the HOA. Let me handle it. Everything goes through me now." I left her office feeling something I hadn't felt in weeks. Not peace. Not yet. But direction. Purpose. They'd taken my shed. They'd trampled my property. They'd threatened my rights. But now I had leverage. I had documentation. I had legal representation. And I had every intention of making them answer for what they'd done. Elise Warner thought she could bully me into silence. She thought a title and a threat were enough. She was about to learn otherwise. Rebecca sent the demand letter 2 days later. I didn't see it before it went out, but she forwarded me a copy afterward. It was 5 pages, single-spaced, methodical and merciless. It laid out every violation in detail: trespass on private property, destruction of personal property without legal authority, failure to follow due process. It cited specific statutes from state property law, referenced case precedent where HOAs had lost similar disputes, and demanded $15,000 in damages, reimbursement, and attorney fees. It gave them 10 days to respond. She said most HOAs settled within a week once they realized how exposed they were. I said I hoped she was right. She said, "Trust me, I've done this before." While we waited for their response, I started digging into the HOA's financials on my own. Rebecca had said, "Follow the money." That in her experience. Aggressive enforcement like this usually tied back to budget pressure or personal gain. I went back to the HOA website and pulled every annual report I could find, going back 5 years. The budget summaries were vague, but there were patterns if you looked closely. The line item for capital improvements had grown every year, but there was no corresponding list of completed projects. The landscaping budget had doubled, but the common areas didn't look any different. And the reserve fund, the money set aside for emergency repairs, had dropped by 40% in 2 years. No explanation, just a number that kept shrinking. I called a neighbor I'd talked to a few times, a guy named Paul who'd lived in the community for over a decade. I asked him if he knew anything about recent HOA projects or major expenses. He said, "Not really." But he'd heard rumors that Elise had pushed through some contracts without full board approval. He didn't have details, just second-hand talk from people who attended meetings more regularly than he did. I asked if he knew anyone on the board I could talk to. He gave me the name of the man with the reading glasses from the meeting. Said his name was Tom Feldman, that he was reasonable, and that he'd been asking questions about the budget himself lately. I thanked Paul and made a note to reach out. 2 days later, I hired a surveyor, not the county surveyor who'd done the original work, but an independent firm that specialized in boundary disputes. I wanted documentation that would hold up in court if it came to that. They came out on a Saturday morning with GPS equipment, spent 3 hours taking measurements, cross-referencing the county records, and mapping every inch of my property line. When they finished, the lead surveyor handed me a printed report. He said your shed was 22 feet inside your boundary. It wasn't even close to HOA jurisdiction. I asked if he'd testify to that if needed. He said absolutely. Happens more often than you'd think. People get bullied by HOAs that don't know where their authority ends. I added the survey report to my file. Then I did something I hadn't planned on. I drove to the county recorder's office downtown and requested copies of all filed documents related to the HOA. Covenants, bylaws, amendments, any liens, or legal actions. The clerk said it would take a few days to pull everything. I said that was fine. I paid the fee and left. 3 days later, I got a call saying the documents were ready. I went back and picked up a stack of papers 2 inches thick. I spent that evening going through every page. Most of it was standard. The original covenants from when the neighborhood was developed. A few amendments over the years. Mostly minor updates to landscaping rules and parking regulations. Then I found something that didn't fit. An amendment filed 8 months earlier, signed by Elise Warner as treasurer, granted the board expanded authority to acquire and manage adjacent properties for community use. Adjacent properties. I read it 3 times. The language was careful, wrapped in bureaucratic phrasing about enhancing property values and expanding recreational opportunities. But what it actually said was the HOA could claim authority over land that bordered common areas if the board determined it served the community's interest. I pulled out my plat map and traced the property lines with my finger. My land bordered the community walking trail on one side. Technically, that made it adjacent to a common area. The amendment didn't give them the right to take my land, but it gave them a flimsy justification to argue they had oversight. And I was willing to bet most homeowners had no idea the amendment existed. I checked the HOA meeting minutes from that month. The amendment wasn't listed. No vote, no discussion, just filed quietly with the county and added to the official record. I took a photo of the amendment and sent it to Rebecca with a message. Found something. Call me when you can. She called 20 minutes later. I explained what I'd found. She was quiet for a moment, then said, "This is good. Really good. If they filed an amendment without homeowner approval, that's a violation of state HOA law. Amendments to governing documents require a vote. If she bypassed that, the amendment isn't valid. And if the amendment isn't valid, they have even less justification for what they did." I asked if that meant we had more leverage. She said it means we have them cornered. I'm updating the demand letter. This just became a much bigger problem for them. The next day, I got an email from Tom Feldman, the board member with the reading glasses. He said he'd heard I was asking questions about the budget and that he'd like to talk off the record. We met for coffee that afternoon at a place outside the neighborhood. He didn't waste time. He said he'd been on the board for 3 years, and in the last 18 months, Elise had become increasingly difficult to work with. She made financial decisions without consulting the other board members, refused to provide detailed reports, and deflected every time someone asked for specifics. He'd raised concerns at multiple meetings, but the other board members either didn't care or were too intimidated to push back. He said, I don't have proof, but I think she's been misusing funds. The numbers don't add up. I asked if he'd be willing to go on record with that. He hesitated, then said, if it comes to it. Yes, but I need to be careful. She has a lot of influence here. I thanked him and left. I sat in my truck in the parking lot, staring at my phone, piecing it all together. The invalid amendment, the missing reserve funds. The contracts were pushed through without approval. The aggressive enforcement that made no legal sense unless you understood it wasn't about rules. It was about control and money. Elise Warner wasn't just abusing her authority. She was covering her tracks. My shed wasn't the problem. I was. I'd asked too many questions. I'd pushed back too hard. And now she was scrambling to shut me down before anyone else started looking too closely. But I was already looking. And I wasn't the only one anymore. The special meeting was called 2 weeks later, prompted by a petition signed by 37 homeowners demanding answers about the budget and the incident with my shed. Tom Feldman had been quietly circulating the petition after our conversation, and once people started hearing the details, signatures came fast. The meeting was scheduled for a Saturday afternoon in the community center, the same room where Elise had threatened me with a lien. This time, the room was packed, every seat filled, people standing along the walls, more outside, looking through the windows. I'd never seen this many neighbors in one place. Rebecca came with me. She sat in the front row, a leather portfolio on her lap, calm and professional. Tom Feldman was at the board table again, along with the other 3 members. Elise sat in the center, her binders stacked in front of her, her expression tight and controlled, but I could see the tension in her shoulders, the way her fingers drummed against the table. She knew this wasn't a routine meeting. She knew people were angry. Tom opened the meeting. He said they were here to address concerns raised by homeowners regarding financial transparency and recent enforcement actions. He said the board took these concerns seriously and wanted to provide clarity. Then he turned to Elise and asked her to walk through the last 2 years of capital improvement spending, line by line. Elise's jaw clenched. She said the information was already available in the annual reports. Tom said the annual reports don't have enough detail. People want specifics, projects, contractors, amounts. She hesitated, then opened one of her binders and started reading off numbers. Landscaping upgrades, trail maintenance, reserve fund allocations, all broad categories. No names, no invoices, no backup. I raised my hand. Tom nodded at me. I stood and said I'd like to ask a specific question. Last year, the reserve fund dropped by 40%. Where did that money go? Elise didn't look at me. She said it was reallocated to cover operational shortfalls. I said, what shortfalls? Our dues haven't changed. What operational costs required pulling from reserves? She said, that's a complex financial question that requires context. I said, then provide context. She didn't answer. The room stayed silent, everyone waiting. Finally, Tom leaned forward and said, Elise, people are asking reasonable questions. If you can't answer them now, we need to schedule an independent audit. Elise's face flushed. She said an audit isn't necessary. The finances are sound, and this meeting is turning into a witch hunt. Rebecca stood up. She introduced herself, said she was representing me in a legal matter against the HOA, and that she'd like to address the board. Tom said, "Go ahead." Rebecca opened her portfolio and pulled out a document. She said 10 days ago, "I sent a demand letter to the HOA regarding the destruction of my client's property. To date, we've received no response, but in the course of preparing our case, we discovered something concerning." She held up the document. "This is an amendment to the HOA covenants filed 8 months ago, granting the board authority over adjacent properties. It was signed by Mr. Warner as treasurer and filed with the county. But according to state law, amendments to governing documents require a homeowner vote. Was this amendment ever put to a vote?" The room erupted. People started talking over each other, some asking what amendment, others demanding to see it. Tom looked at Elise. He said, "I never saw this. Did we vote on this?" Elise's hands flattened on the table. She said it was an administrative update, not a substantive change. Rebecca said state law doesn't distinguish between administrative and substantive. All amendments require a vote. This one didn't get one. That makes it invalid. And if it's invalid, the HOA had no legal basis to claim authority over my client's property, which means the destruction of his shed was an illegal act. Elise stood abruptly. She said, "This is out of order. We're not here to litigate legal disputes." Tom said, "Actually, we are. You filed an amendment without authorization. You removed a structure on private property without due process. And you've refused to provide financial documentation that homeowners have a right to see. I'm calling for a vote right now to suspend your authority as treasurer, pending an independent audit and a full investigation." One of the other board members, a woman I'd never heard speak before, said, "I second that." The woman who'd defended Elise earlier spoke up again. She said, "This feels rushed." "Shouldn't we consult our attorney first?" Tom said, "We've consulted enough. We're voting now." The vote was 3-1. Elise was the only one who voted against it. Her face went pale. She said, "You can't do this." Tom said, "We just did. Under Robert's Rules of Order, a majority vote of the board is sufficient to suspend an officer pending investigation. You're relieved of your duties effective immediately. You'll need to turn over all financial records, all contracts, and all correspondence related to HOA business within 48 hours. If you refuse, we'll pursue legal action." Elise grabbed her binders, shoved them into a bag, and walked out without another word. The room stayed quiet for a moment. Then someone in the back started clapping. It spread slowly, awkwardly, until half the room was applauding. I didn't clap. I just stood there, watching the door she'd gone through, feeling the weight of the last 2 months lift just slightly. It wasn't over. There would still be an audit, still be a lawsuit, still be answers to find. But the person who'd taken my shed, who'd threatened my property, who'd abused her authority for whatever reasons she had, was no longer in power. And everyone in that room had seen it happen. Rebecca looked at me and smiled. I smiled back. Then we sat down and waited for the meeting to continue. The audit took 3 weeks. The board hired an independent accounting firm, gave them full access to every record, every bank statement, every receipt Elise had kept or failed to keep. Rebecca stayed in regular contact with Tom Feldman, who called her twice a week with updates. He said the auditors were finding discrepancies, lots of them, but they needed time to trace everything. I waited. I rebuilt the shed in the meantime, using the insurance payout I'd gotten after filing a claim for malicious destruction of property. The new one was bigger, sturdier, and sat in the same spot. The audit report came back on a Thursday. Tom called me that afternoon and asked if I could come to an emergency board meeting that night. He said I'd want to hear this in person. I went. Rebecca came with me. The room wasn't as packed as the special meeting, but there were maybe 20 people there, all waiting to hear what the auditors had found. Tom stood at the front with a printed report in his hands. He didn't waste time. He said the audit revealed significant financial mismanagement and probable embezzlement over the past 2 years. Elise Warner had authorized payments to contractors for work that was never completed or never verified. She'd written checks to shell companies that didn't exist or were registered to her husband. She'd transferred money from the reserve fund to cover operating expenses she'd created by overspending in other areas. In total, nearly $60,000 was missing or misallocated. The room went silent. Someone in the back said 60,000. Tom nodded. He said the auditors found invoices that didn't match bank records, expenses coded incorrectly to hide their purpose, and multiple violations of the HOA's own financial policies. It was systematic, it was deliberate, and it had been going on for at least 18 months. He said the board had already voted to refer the findings to the district attorney's office for potential criminal prosecution. They'd also voted to file a civil lawsuit against Elise Warner to recover the stolen funds, and they'd voted to reimburse me in full for the cost of my shed, plus damages, plus attorney fees. Rebecca leaned over and whispered, "That's everything we asked for." I nodded. Tom kept talking. He said the board was also invalidating the amendment Elise had filed without authorization and implementing new financial oversight procedures. All expenditures over $500 would require board approval and documentation. The treasurer position would be subject to term limits. An independent auditor would review the books every year. He said we failed as a board to catch this earlier. That's on us. But we're fixing it now. And we owe Dylan Cole an apology. What happened to him was wrong. It was illegal. And it never should have happened. A few people turned to look at me. I didn't say anything. I just sat there, listening, feeling the vindication settle into something quieter than I'd expected. This wasn't about revenge. It wasn't even about the money. It was about being right. About standing up when someone with a clipboard and a title tried to take what was mine. About not folding when the pressure got heavy. Elise Warner had thought she could bully me into silence. Thought she could hide behind procedure and bureaucracy. Thought no one would check her work. She was wrong on all counts. Tom said the district attorney would decide whether to file criminal charges. That wasn't up to the board. But the evidence was clear, and the auditors had flagged multiple instances of fraud and breach of fiduciary duty. If convicted, Elise could face restitution, fines, and possibly jail time. The civil lawsuit would proceed regardless. The HOA was also considering a recall election to replace the remaining board members who'd failed to provide oversight, though Tom said he'd resign voluntarily at the end of his term. The meeting ended 20 minutes later. People filed out quietly, some stopping to shake my hand, others just nodding as they passed. Rebecca and I walked to the parking lot together. She said you did well. You stood your ground. Most people don't. I said I had help. She smiled and said, "That's what lawyers are for." She said the HOA's check should arrive within a week. After that, we were done. I thanked her. We shook hands. Then I got in my truck and drove home. The shed was still there, exactly where I'd built it. The lights were on inside. The door was locked. My property, my rights, intact. The check arrived 6 days later. Certified mail, signed by Tom Feldman on behalf of the board. It covered everything. The materials for the shed, the labor I'd put in, the surveyor's fees, Rebecca's attorney costs, and $5,000 in damages for the trespass and emotional distress. I deposited it the same afternoon, then went home and stood in the backyard for a while, looking at the new shed. It was painted the same color as the old one. The door hung the same way, and the roof pitched at the same angle, but it felt different now. Not because of what it were, but because of what it represented. Proof that standing your ground matters. Proof that rights mean something when you're willing to defend them. The neighborhood changed after that. Slowly, but noticeably. The new board implemented the oversight measures Tom had promised. Monthly financial reports started showing up in everyone's mailboxes, detailed and transparent. The annual meeting that spring had twice the usual attendance. People asking questions, paying attention, holding the board accountable. A few neighbors I'd never spoken to before stopped by to thank me. Said they'd been frustrated with the HOA for years but never thought they could push back. One guy said, "You reminded us we're not powerless." I told him he never was. Elise Warner moved out 3 months later. I heard about it from Paul, who'd heard it from someone else. She and her husband sold the house quietly. No sign. No open house. Just gone one weekend. The DA filed charges 2 weeks after that. Fraud, embezzlement, breach of fiduciary duty. I didn't follow the case closely, but Rebecca sent me updates when there was news. Elise pled guilty to avoid trial, was sentenced to 18-month supervised probation, ordered to pay full restitution to the HOA, and barred from serving on any HOA board in the state. No jail time, but her reputation was finished. The civil lawsuit was settled a month later. The HOA recovered most of the missing funds. I kept working, kept mowing my lawn, kept living my life the way I had before any of this started. The shed sat in the backyard, solid and unremarkable, holding tools and boxes and all the ordinary things a shed is supposed to hold. Sometimes I'd walk past it and remember that Saturday in June when I built the first one. The heat and the smell of fresh-cut wood, and the satisfaction of making something with my own hands. Other times, I'd remember coming home to find it gone. That cold shock of seeing the empty concrete pad. The moment I realized someone thought they could take what was mine. Both memories mattered. One reminded me what peace felt like. The other reminded me of what it cost to keep it. And I'd pay that cost again if I had to. Every time. Without hesitation. Because some things are worth fighting for. And this was mine. If this story resonated with you, you're not alone. Too many people face HOA overreach, workplace injustice, or someone abusing authority, and they don't know where to start fighting back. That's why this channel exists. Every week, I bring you real stories of people who stood their ground, demanded accountability, and won using the law, not violence. If you want more stories like Dylan's, hit subscribe and turn on notifications. Drop a comment if you've ever dealt with an HOA nightmare. Let's build a community that doesn't back down. Welcome to Gated Drama.